Good morning and welcome everyone to today's presentation, 2019 Legislative Update to Maine Employment Laws. Welcome, you're Verrill Dana. If this is not the event that you were planning on attending, you're welcome to leave now. Neither Paul nor I will be offended. As you realize, we are also using a webinar kind of for this event for our friends way north, so that they did not have to drive down and have this lovely breakfast with us. So, I'm Tawny Alvarez. I'm a labor and employment attorney here at Verrill Dana. There are other attorneys in the room. I make sure that they identify themselves so that you guys don't think that we're tricking you as we mingled amongst you and you don't realize how boring we really are. So, attorneys in the room, from Verrill Dana, you can identify yourself. This is that moment.
We're truly exciting. What's this?
And I will also turn it over to Paul to introduce himself, MassPay, and his team.
So my name is Paul Carelis. I'm the Vice President of HR Services over at MassPay. So MassPay's been around for 15 years now. We started off as a payroll provider, and then over the years, based on kind of our clients' wants and needs and their employees' wants and needs, we've evolved into a human capital management software provider. And I guess most excitingly, the division that I head up beyond HR, we provide strategic and compliance HR consulting to businesses of all sizes throughout the country.
So the goal of today, there's a lot of information to cover, but we also want to make sure it's accessible to everyone. So the setup for today is going to be that you're going to get an outline of what Maine law is on a certain subject, really briefly. It's in more detail in everyone's slides. Then we're going to talk about the legislative updates that has occurred in that realm within this session. Questions are welcome throughout the course of the presentation. If it's a longer answer, it's very specific to a certain industry, we're likely going to table that information. Sign-in sheet. By signing up and registering, we have your contact information, which means we can send you these slides afterwards, so you don't have to worry about going back to your office, photocopying, any of those things. We'll send you the slide deck. And seminar evaluations, we always like to hear what you think of us. Honestly, I think that sounds weird, but tell us what you think. So definitely keep that at top of mind at the end. You can see anyone from MassPay or Verrill Dana and give them your honest assessment of where we're at. You also are going to get feedback throughout the course of the presentation from other attorneys in the room who are going to provide additional information as to some of these statutes. So with that, we'll move forward.
All right, so first on discrimination. Under the Maine Human Rights Act, or MHRA, all Maine employers, regardless of size, so no minimum there, are prohibited from discriminating against current and prospective employees based on certain prescribed characteristics.
So what happened this session with regards to the Maine Human Rights Act? Interesting, we had a resolve. So this wasn't a statute, no money went kind of towards it. But it directed the Maine Human Rights Commission to implement a pilot program. Normally, we wouldn't have a big discussion about this because it doesn't affect your day-to-day operations, right? But we always like to make sure that you guys are planning ahead for what changes in the law are going to look like in 2020, 2021, 2022. This is a 2-year pilot program. There's an interim report that's due in September 2020. And the final report will be due in September of 2021, which means we likely see, if this has an effect, changes in 2022. What it is going to do is potentially create an additional protected class for homeless individuals. So individuals who don't have a residence or who are homeless would then be fall within the protected class under the Maine Human Rights Act. That's the way the language is set up, what this pilot program is attempting to determine. The other thing that's less clear, is lack of employment as being a protected class. So does that mean that you could have a discrimination claim for your refusal to hire someone who has been unemployed for a significant period of time, right? It'll be interesting to see the information and data that comes out of this pilot program, but keep those topics at front of mind kind of as we move forward as to what we see the arch of protected classes being moving forward. Additionally, an act to protect pregnant workers. This was passed to be enacted. It was passed signed by the governor on the 19th. It's going to be an amendment to 5 MRSA 4,553. It provides that you have to provide specific accommodations for pregnancy-related conditions. It'll be considered unlawful discrimination to fail to provide a reasonable accommodation unless it's an undue hardship. And it sets forth very specific accommodations that may be necessary, including allowing women or individuals is the words used in the statute itself. They don't use women, they use individuals to pump at work, to sit, to take time off. The reason we haven't seen a ton of discussions in the media about this act is because you already have this duty under the Federal Pregnancy Discrimination Act. So that's why we haven't been talking about it a ton, but it would put Maine in line with what the federal requirements are.
I mean, in terms of best practices with these items, when it comes to protected classes, the first place you kind of want to examine is your interviewing and selection process. So that starts off with your job postings. When people are applying, what are they seeing? What are you advertising for a job posting? Is there language in there that might either be discriminatory towards a protected class or even chilling to a protected class based on what you're looking for in the ideal candidate? Is it being restrictive or kind of eliminating certain groups of people? And not so much here in Maine just yet, but we're seeing a lot of proactive action with that. So I have a client who has a location in San Francisco, and they got a really kind of nasty letter in the mail because one of the governmental departments in San Francisco just was kind of combing through job postings and saw that one of their postings potentially discriminated against individuals who protected based on arrest and conviction records. So there is a lot of proactive action going on with job postings. So certainly look at those. Also, your employment applications. What kind of questions are you asking to your applicants? Again, are there things that might be considered discriminatory or chilling to different protected classes? And then lastly, just making sure that whoever is involved in your hiring process, have they been formally trained in terms of both effective interviewing and legal and compliant interviewing? What kinds of questions are they asking, and what kind of documentation are they keeping in that process? As for the pregnant workers, the biggest thing you want to do and really train your managers and supervisors on is not to make assumptions. Don't assume because someone is pregnant what they can and cannot do. This is a really strong argument to have strong job descriptions, make sure those have been updated, and then sit down. When someone comes forward and announces that they're pregnant, sit down, look at the job description, and make some determinations. What reasonable accommodations, if any, need to be done, and just have that interactive conversation.
And I think that, to add on to what Paul said, that's something we're seeing more and more lately, or getting more calls about, is situations in which during the application process, the employer learns that someone's pregnant. They then call saying, Tawny, this is a really strenuous position, like you're on your feet all day long, or you're lifting, or you're doing all these activities. The response is, have you told the individual that these are the job duties and responsibilities from a physical standpoint? If the answer is yes, and the individual has indicated that they can perform those tasks, okay, are they otherwise qualified for the position? You're going to take the pregnancy out of the mix. And some people say, well, I don't want to hurt the baby, right? I don't want to hurt the baby, I don't want to hurt her. Well, that's not your choice. If she's saying that she can perform the job, then she can perform the job, and you're not going to limit her ability to have the job as a result of her pregnancy status.
All right, next is equal pay law. Definitely a hot topic in a number of states. Maine is no exception. So, quick quiz. Employers may restrict employees' discussions about their wages. You guys are on top of it. Correct. One more. Employers generally may not prohibit employees from discussing either their own wages or their coworkers' wages, or from disclosing wage information to any person or entity. What's there? Also false.
What would be one way in which that you could restrict someone from discussing coworkers' wages?
They work in the HR.
Yeah, yes, if they are privy to information either in the HR department or as a manager, they have access to everyone's wage information. In those situations, you're appropriately going to be able to say, this is confidential information that you should not be sharing with your coworkers or other members of the organization.
So, the Maine Equal Pay Law prohibits employers from discriminating against employees in the same establishment on the basis of sex by paying wages to any employee in any occupation in the state at a rate less than the rate it pays any employee of the opposite sex for comparable work on jobs requiring, and this is the important part, comparable skill, effort, and responsibility. So this is kind of where you see the laws differ state by state. What is the definition of comparable work? For Maine, it's based on skill, effort, and responsibility.
And interestingly enough, everyone, if you're following the news, you know that every state is creating some type of equal pay law. This is a language that we've had in Maine for a period of time, and it's interesting that we've used opposite sex. In many states right now, what they're grappling with is that when they created the legislation, they said that you can't pay a woman less than a man, right? Which has now created a whole host of issues. Thankfully, when this was drafted, it was very broad in saying simply the opposite sex.
So under this law, it's unlawful for an employer to reduce any employee's wage rate in order to comply with the law. So if you see a discrepancy, you can't bring someone down. They're being paid higher than someone else. Require or permit any person as a condition of obtaining or keeping a job to work without monetary compensation or to agree to a return part of their compensation to the employer, or discharge or discriminate against any employee for invoking or assisting in any manner in enforcement of this law. As long as the following systems or circumstances don't discriminate on the basis of gender, an employer may apply different rates of pay when they're based on any of these three bullet-pointed items: an established seniority system, merit increase system, or a shift differential.
So what happened this legislative session related to this law? We had LD 278, an act regarding pay equality. It was signed on April 12th, 2019, and this act got a lot of play in the news media. So employers, and this is the exact language of the statute. I know I usually say don't put everything in a slide, make it readable. This is something that I think it's important for everyone to understand exactly what the statute provides. So you cannot use or inquire about compensation history of a prospective employee from that prospective employee or a current or former employer of the prospective employee unless you've already offered employment to that individual, and that offer of employment includes all the terms of compensation that have been negotiated and are finalized. You can, however, after you've made that offer with all the compensation terms, you can inquire about or confirm the prospective employee's compensation history. Now, why does that matter? Why would we include that, right? I don't know. I don't know why you would call afterwards and ask. Arguably, my mind goes to, okay, well, if you have language on the bottom of your application that says if you've provided any false or misleading information here, then you're not eligible for employment or we can revoke any offer. The problem is you can't ask what their previous salary was, so how are you confirming it after the fact and then attempting to remove them from the organization? If somebody has thought of or experienced a point in time in which it was necessary or important to find out or confirm that compensation history after the full offer has been made and accepted, I'd love to talk offline about that. We internally, I don't think any of the other Verrill Dana attorneys have come up with a reason why that's necessary. Team? No. So the employee, however, can voluntarily disclose the pay history without prompting during the course of the employment application process or the interview. Now, this puts employers in a really difficult situation where they're receiving information that they know that they should not have. Paul's going to talk a little bit about best practices as to how we can deal with that, but if they voluntarily disclose it, you're not in violation of the statute. You can, however, inquire about compensation history if it's required by any federal or state law that says that you need that disclosure for employment purposes. The violations, for each time this occurs, it's a civil fine between $100 and $500, and the applicant or employee, if you do hire them, has the ability to file a civil action against you.
I mean, in turn, question?
But you can ask like what compensation they're seeking, not what the history is, but what they're seeking, right?
You can, I mean, on the risk scale of things that we recommend, I recommend saying that the pay for this position is between X and Y, or the pay is this. Is that comparable to what you're seeking? Yes or no, right? You should have come into that interview knowing what that position is worth for your company or what you're going to pay for it. The question that becomes more difficult is when you have an applicant who is highly overqualified and doesn't fit within the parameters of the job that you're seeking, and then you consider making or creating a new position for that individual, which might have a higher pay bracket, right? That becomes more of that discussion to say like, okay, well, this was the realm that this position was for. I was between X and Y. But if I'm creating a new position based off of this person's skills and abilities and my desire to have them as part of the company, what are the parameters that you're going to set for that position, and does it fall within what they're seeking?
Yeah, I mean,
Does this just deal with pay rate or total compensation? So do I have to give the same bonus, offer the same benefits like in Massachusetts, or is it just literally what I get on a biweekly or monthly basis?
They use the language compensation history. So if they're making $40,000 a year, but their bonus structure is such that they could be taking in another $80,000, right? That you can't seek even what the bonus structure was, because I think that's going to be considered compensation history in some format. Same with, I mean, any other form of compensation that could be present.
We just removed the start and end pay off our applications in preparation of this. We have some on file, for the past year. Should we worry about that, or?
If you had been asking for the data prior to this law taking effect, there's not going to be a problem, and that past data isn't going to be held against you moving forward. But I would make sure that any applications that you have kind of out there or pending that you haven't received back, if they had those columns on it, that you would get them an updated application. If possible, it doesn't take effect until September, so you've still got some time here, but just to be mindful of it and taking those steps you just discussed is important.
On our applications, it asks what compensation are you seeking for your rate? We did remove the history of compensation. Should we remove that question also?
I mean, no, any discussion about it is a higher risk. It's a higher risk, but the good news is that by having it on there, you're very specifically saying what you're seeking. You're not seeking the past, but what they're seeking is likely based off of what they're currently making, and that's what their universe is going to be. And I think Richard has something to add to that discussion as well.
Depending on how you view California as the fringe of the country or just the West Coast, clearly out there, that issue is becoming a big thing because they're now arguing that under pay equity, women negotiate less well. I think they negotiate fine, but they don't negotiate as true as often or as hard necessarily for a starting wage. And they historically, because many women's jobs have been paying less than they maybe currently should be or would be paid under a different system, they come with a lower wage history. So their expectation may be less. So the new standard of challenge is you're building in a wage disparity by asking them what they want, because they're going to ask for less, and you're going to end up with them making less, doing the same job that a man has as well, perhaps even in the exact same location. And your defense that, well, that's what they asked for, is not going to ring really strong. So you have to really look at that question. What Tawny said earlier is what I think is the best practice, and it's the one that the plaintiff's lawyers have the most difficulty going after. What's the job worth to you? Figure out whatever, whether it's a parameter or a fixed figure, and say that's what the job's worth, and then decide to pay everybody within that range when you hire them, whatever their particular diversity may be.
Yeah, great point. In terms of best practice, again, it really speaks to the importance of making sure managers, supervisors, or whomever you have involved in your interviewing process has undergone some extensive training and is up to speed on all of these kind of new pitfalls that are out there now, that they're not asking questions like this, or even leading questions like this. And then in terms of interviews kind of getting off track or learning information that you don't want to, the best practice, especially if you have people that are a little bit more junior involved in the process, develop an interview template. So every interview is going to go in its own direction a little bit, but if you can kind of have a baseline of standard questions that you know everyone's going to be asked, and if things get off track, they know what the next question is supposed to be and kind of lead the conversation back there, that's going to help for purposes of this. And then also really for other discrimination claims, if you know that every candidate's being asked the same set of questions, it makes the selection process easier because it gives you more of an apples to apples comparison. How did candidate A answer question 1 versus how did candidate B answer question 1? And again, just helps keep things on track a little bit. As for some of this other stuff, when we talk about merit increase systems and things like that, again, take a look at your review process, make sure it's effective, make sure it's objective, really take a look at your performance reviews, use them effectively, and make sure that they don't have anything troubling with them.
And recall that different managers, I mean, you have some sugarcoating managers and you have some realistic managers, which potentially leads to a situation in which you have same department or same kind of jobs, but people are being reviewed by different managers. Some are harder reviewers than other ones are, which leads to potentially this group that is making more money or getting better raises simply because of the individual who is overseeing the review process, right? That's the point in time in which you as HR need to be proactively going through the documents and saying, hey, hold up, I've got one whole team that is significantly below this other team doing the same tasks and jobs, right? Why is that? Well, it's likely because of the manager and how he or she rates performance. Making sure that you figure out a way to get those numbers in line is important.
And in my practice, again, another really great opportunity for training, making sure everyone's on the same page with what your expectations are for the performance review process. And again, in my practice, where I've seen it be the most troublesome is the manager who tends to kind of have the halo effect, giving everyone higher marks than they deserve, because those people are being told they're doing a great job. It's being documented that they're doing a great job. So if they go for a promotion and don't get it, or they get terminated, or whatever it may be, they're left thinking, hey, on paper, I'm a star employee. There must be some potentially discriminatory reason as to why I'm not getting this promotion, or why I'm being shown the door. So if nothing else, I find that the overly positive reviews are those that tend to be the most troublesome. All right, everyone's favorite topic, sexual harassment. So, in the Maine Human Rights Act, it prohibits discrimination on the basis of protected class. Sexual harassment is considered a form of unlawful discrimination, I think, which we all know. Unwanted sexual advances, requests for sexual favors, or other verbal or physical conduct of a sexual nature, which threatens job security, working conditions, or advancement opportunities, is considered sexual harassment. It's a violation of the law to retaliate against any person exercising his or her rights under the law. Under MRSA Section 807, it requires employers with 15 or more employees in the workplace to conduct a sexual harassment education and training program for all employees. Employers are further required to conduct additional training for supervisory and managerial employees. And a good way to threaten your managers and supervisors, they may be held individually liable for sexual harassment as an employer.
Now, the way that we kind of describe this, and this is that, you know, we talk about scaring people. They need to recognize that any of their activities kind of bind the organization. As managers, they themselves have the ability to bind the individual employer. So if they're sexually harassing someone, it's the employer who's sexually harassing that individual, and there's not any need to show that notice was given to the organization. From an individual liability standpoint, them being named, them having to have separate counsel, that's a different type of liability that's not an issue here. But this recognition that they are binding the organization is extremely important. In addition to things that people should be aware of and making sure that they're on top of, you also have the duty to yearly provide a written copy of your policies and procedures regarding sexual harassment to all of your employees. And we're seeing that that's sometimes falling through the cracks, so make sure that you yearly are providing that update to your employees regarding rights and responsibilities under the state sexual harassment statute.
Tawny, can I ask a question?
Oh, yeah, sorry, yeah, yes, and then, yeah.
The posters,
Yes.
current posters considered notification?
No. You have to have individual notification to every individual, like in either it can be electronically, it can be like, hey, here's a copy of the policy, send the read request, tell me that you got it, that kind of thing. It can be in paper, sign the piece of paper and return it to HR. The posting of the notice itself is insufficient. Additionally, anyone who closely follows the Maine Department of Labor website, you'll notice that in the revised statute there is discussion regarding a checklist that will be created by the Maine Department of Labor concerning best practices as to sexual harassment and training. Never in my life have I seen a document that looks less like a checklist than the document that was created by the Maine Department of Labor. It's a one-page document. It's got 2 columns. On the right-hand side, it's a bluish shaded color. The rest just has text about your duty and obligations, and it says Maine Department of Labor at the top, right? So if you are searching or have spent time searching for a checklist created by the Maine Department of Labor, and you're looking for a true checklist, that does not exist. You have found the one-page PDF that is expected to hit the points that the legislature was asking for a checklist. We had another question in the back, yeah.
Yeah, seasonal staff, seasonal employees, short-term seasonal employees.
We recommend doing it. It's best practices to make sure that you have papered everyone with what their rights and obligations are under the statute. Additionally, if they are new seasonal employees, you have that duty or obligation to train if you have 15 or more employees. So hopefully during that training, you can do a yearly training for everyone and also give them a copy of the document and just take that right off your list. So what happened this session? So nothing happened this session, but something likely will happen next session. So an act concerning non-disclosure agreements in employment, it was carried over to the next session, so we likely will see action on it next year. But what it does, what the statute does, is it limits pre-employment and employment agreements from including any language regarding non-disclosure, non-disparagement, or waiver provisions that prevent the employee from disclosing or discussing discrimination between an employee and employer in the workplace, at work-related events, or off the employer's premises. This wouldn't seem like it's super big because you're like, well, what does that matter? We don't usually call out sexual harassment anyways. The problem is we don't call out sexual harassment. Usually it's a very broad statement saying like, don't discuss confidential information. This is something that we prefer you keep kind of, you know, within a small community as we investigate it. We say that during the course of an investigation often, like don't go sharing this with everyone kind of thing. So we're going to need to be really mindful of looking at any employment agreements that we have now and in the next legislative session to make sure that we are not accidentally violating the statute in that sense. Now, with regards to settlements, separation agreements, and severance agreements, this is where it gets really nitty-gritty. Unless the employee, him or herself, requests that the term is included in the settlement, separation, or severance agreement, you cannot include language that prevents the disclosure of factual information relating to a claim of sex discrimination, including harassment, right? Now, people who followed the recent federal tax bill know that there are tax implications to including a non-disclosure statement in any settlement agreement if it involves sex harassment. This moves the state standard closer to that tax aspect, but instead of this being purely a tax act, this becomes an employment law and kind of obligation. There is very specific required language concerning the individual's rights with regards to filing a complaint or a claim with the Maine Human Rights Commission and the Department of Labor that would need to be included in any agreement. And there's also an extension of time for the individual to review the document and to revoke the agreement. So it's similar to the ADEA, or the Older Workers Benefit Protection Act language, where you are going to have to provide the 21 days in order to review any of these documents. This is an act or a statute that Verrill Dana is very much on top of and has their finger on the pulse of it. If you're using someone other than Verrill Dana, make sure that you have just a note to yourself that if you do have settlement agreements or separation agreements that are going through council, that you're keeping this at top of mind moving forward as to what the status is of this claim, of this statute, so that you don't find yourself with a separation, settlement, or employment agreement that's invalid.
Yeah, and as Tawny said, if you have an old template that you've been using for years, a release of claims or whatever it may be, now's a great time to work with your legal counsel, make sure that that's updated, that it's accurate, that it's compliant, because usually when you're doing a severance or separation agreement, you're looking to kind of close the door and free yourself of liability. And a law like this can really change that equation really quickly. All right, minimum wage, hot topic throughout the country. So effective January 1st of 2019, hopefully we're all in compliance here. The state minimum wage here in Maine is $11 per hour. As of January 1st of 2020, that will be increasing by $1 to $12 per hour.
One of the reasons as well that we wanted to make sure that we highlighted this is recall that under the Maine statute, the minimum wage is also tied to your salary exempt workforce. So you need to make sure that if you have salary exempt employees that they're making 3,000 times what the state minimum wage is, right? So at $11 an hour, you get the 33,000. In 2020, if you have anyone who's making the 33,000 who you're using as an exempt employee, you're going to have to increase their rate of pay on January 1st of 2020 to make sure that you're maintaining that exemption appropriately.
So here within the city of Portland, as of July 1st, the city of Portland minimum wage will be $11.11 per hour. So small difference, but an important one. All right, service employees. Several state and federal prerequisites that still must be met before the tip minimum wage can be used. The Maine labor law allows tipped employees to be paid a lower cash wage than the standard Maine minimum wage. $5.50 in tips earned per hour can be deducted from the wage as a tip credit. With the minimum tip credit taken, tipped employees must be paid a cash wage of at least $5.50 per hour for a total minimum compensation of $11 per hour, including tips.
And recall, I mean, specifically in Portland, it's going to have to be $11.11 an hour for you to meet that. So I don't think we have a ton of service people in the audience, but just keep that in mind.
In terms of the definitions, employees must regularly receive more than $30 a month in tips to be classified as a service employee. And no tipped employee should ever receive any actual wages less than $11 per hour when the tips are factored in. If the combined wages and tips don't average on a weekly basis the state or municipal minimum wage, you as the employer are responsible for the difference there. The tip credit claimed by the employer can't exceed the amount of tips actually received by the tipped employee. All tips must be retained by the employee except in the case of a lawful tip pool. And the tip credit may only be applied to a tipped employee who has been informed of the tip credit rules. Make sure that's communicated to those of you who do have tipped employees.
So what happened this legislative session? We had LD 81, which was signed on March 25th. An act to clarify Maine law regarding the tips of service employees. What it did is it really put us kind of in line with what the federal requirement was. One of the most difficult things about kind of the Maine wage and hour statute is the fact that it is so different from what is set forth in the FLSA, and yet at the same time they keep relying on the FLSA to figure out what they meant by it. The more that they can continue to update the wage and hour laws to put them in line with what the federal standards are, the easier it is going to be for everyone who is owning and operating a business in the state of Maine. So it allows a valid tip pooling arrangement among service employees, right? Service employees isn't defined, but you're gonna look at the FLSA to get a better sense as to what that means. And it says it does not violate the Federal Fair Labor Standards Act and regulations, and that's an interesting aspect of it because we're looking at the regulations as well that are made pursuant to the act. Considering how much the FLSA has been flipping and flopping as to what tip credit can be used, what a service employee is, thankfully this just puts us in line with the unknown under federal law instead of us saying, okay, there's unknowns under federal law and also here's what we're dealing with under state law. Just provides us with one general unknown, which is easier to deal with.
I mean, and in terms of best practices, just proceed with caution if you do have a tip pooling arrangement. Who is eligible and who is involved in receiving tips under the tip pool. And this can vary state by state. I know that Maine's kind of following the federal lead, but if you look at very similar case law from one state to another, there's been very different definitions in terms of people with managerial or supervisory responsibility, whether they should be eligible to participate in a tip pool. Certainly differentiating between front of house people that are directly serving, in a restaurant setting, the wait staff and the bartenders versus kitchen staff and things like that. So just make sure you're examining and reviewing with HR or legal counsel who's involved in your tip pool if you do have one to make sure that there isn't unnecessary exposure there.
What happened this session with regards to overtime? So under Maine's overtime law, we all know that an employer must pay each employee overtime at a rate of time and a half for hours worked in excess of 40 during any work week. You cannot require an individual to work more than 80 hours of overtime in a consecutive 2-week period. What we had was an emergency legislation which was signed on June 3rd of 2019. This relates to our public employers within the room, and what it did was it exempted public employees who are working in fire protection or law enforcement from the overtime requirements. So it's purely related to public employees. The title doesn't seem to indicate that, so if anyone sees this, an act to amend the laws governing overtime, it's only related to public employers.
So in terms of payment of wages under state law, employers must pay full wages to non-exempt employees on an established pay day at regular intervals of no more than every 16 days. The pay or wages must include all hours worked, including tips, earned vacation pay, promised holiday pay, earned commissions that are definitely determined, due, and payable. Each payment must include wages earned within 8 days of the payday. If the regular payday falls on a non-working day, it must be paid no later than the following business day. And employers are responsible for providing a pay slip or check stub that includes the name of the employer, the name of the employee, the pay period, hours worked, total earnings, and itemized deductions. Okay.
So what happened this legislative session? We had an act to prevent wage theft and employer accountability. It was signed on June 21st, so it was signed on Friday. It adds certain remedies to employer violations of the wage payment and recording statutes, right? So it allows, and this is the crazy part, it allows the bringing of a claim for injunctive relief. Well, Tawny, what would injunctive relief be when you're not paying wages? As broadly as it's set forth, they could shut down your business, right? Which is kind of crazy. It goes a little bit further, goes a lot further than what we see in other states. In other states, you fail to pay wages and you get a lawsuit under the Fair Labor Standards Act or under state wage and hour law. You're gonna have to pay treble damages, attorney's fees. It's already gonna cost you a ton of money, and in a lot of situations potentially could shut down your business. Here, very specifically, could shut down your business, right? The employer remains liable for all costs and attorney's fees related to the action itself. Additionally, in addition to a plaintiff bringing a civil action for injunctive relief, the Commissioner of Labor may order the employer to cease its business operations, right? If the Commissioner determines that they've committed wage theft, which is a violation of a vast quantity of the wage payment statutes, including failure to pay minimum wage, failure to pay overtime, failure to pay out vacation time if it was due and owing after termination of employment. If the Commissioner has previously determined that the employer's practices or policies resulted in some form of wage theft, so the Maine Department of Labor would have had to have come in previously and cited you for failing to perform one of your duties or requirements on more than one occasion or within the last 12 months. That's interesting language because they're saying if it was within the last 12 months or at any time. So I feel like this, within the last 12 months, is additional language that's not necessary. But when a court reads a statute, they presume that all language is necessary in the statute. So it'll be interesting to see what a court says about that language. And the practice or policy that resulted in the wage theft affects 10 or more individual employees, or the wage theft is equal to or greater than twice the employee's average weekly wage. So the Commissioner, in order to seek the injunction to cease operation of the employer's business, is going to have to meet that standard. The interesting part here is there has to be this determination that the employer has committed the wage theft, right? So the determination in this case would be made by the Commissioner of Labor as opposed to if the plaintiff was bringing it and you'd go through the process in the court system to determine whether or not an injunction should be issued, which is a very high threshold. That one's a big one. So questions, comments, thoughts, concerns? Good, well, we've got a lot of other stuff to talk about, so that's fine.
All right, marijuana at work. I think that maze is a very accurate description of kind of how these laws are working on a state-by-state basis. So first, in terms of medicinal use or medical use, state law does allow a person who is at least 18 to lawfully possess a usable amount of marijuana for medical use. It's legal under state law with a medical record or other written documentation from a physician. But employers are not required to accommodate use at work.
Circle, underline, do whatever you want in your notes. We are going to come back to this statement because that's why we're talking about this today.
Exactly.
So that's a big part of it. So we're going to come back to it.
Okay. In November of 2016, Maine voters approved ballot question 1, which read, want to allow the possession and use of marijuana under state law by persons who are at least 21 years of age, so more of a recreational. Under the law, employers may not refuse to employ or otherwise penalize a person 21 years of age or older solely because he or she has consumed marijuana outside of the employer's property. All right, so kind of a checklist here for yourselves as employers or an HR department. A, do you have an anti-drug and alcohol policy? If so, does it include specific language that's particular to marijuana use? Do you consistently enforce that policy? Is it communicated to applicants and employees? And have managers been trained on how to enforce said policy?
When you're looking at your statement or policy, if it does include marijuana, please make sure that it doesn't just include smoking marijuana. I mean, people aren't smoking marijuana anymore. They are, but the use of marijuana is evolving in such ways that if your policy only says you're not allowed to smoke marijuana, they're going to be like, no problem, I haven't smoked it in a while, right? But they're drinking it, they're eating it, they're using it as lotions, all of those type of things. So make sure that your policy isn't just included in your non-smoking policy, saying that you can't smoke tobacco or marijuana.
If you do have a policy, revise it, make sure it covers all aspects of your workplace. So include any vehicles that are used for business purposes, employment duties performed off-site at customer sites, work-related activities, seminars like today, company-owned parking lots and garages, etc.
How would you suggest that you communicate it to applicants?
To applicants, I usually don't bring it up to an applicant. It's kind of the expectation when they get in that it's either a drug-free work environment, there's no smoking on campus of any format. We don't allow, and this is one, I'm going way over the top, and I've had a number of extremely academic and interesting discussions with people. I'm happy to have them afterwards. I've been putting in policies and procedures that you're not allowed to have CBD products on site, whether it's a CBD lotion, whether it's CBD edibles, and everyone's like, but Tawny, CBD is not illegal, right? But if you look under what the FDA says and what the DEA is saying, if it's truly CBD, it has trace amounts of marijuana in it and it's still illegal, right? It's not something I think employers want on their work site or to be dealing with. So there's nothing that prohibits you from limiting it. So I like to just have it in the policy and procedure. I don't usually get into it at all during the application process. Just make sure that they're clear of it when they're employed. If once they enter the workforce, they've indicated that they have a medicinal certification, that starts a different conversation.
Well, and I think you just answered it, but so if you have an employee who uses CBD lotion medicinally and has the certification, that's a whole nother.
It's a whole nother discussion kind of generally as to that, but it's more this CBD product that's just, you can get anywhere, that anyone, we can all have in our purse right now. I like to make sure that our policies and procedures very specifically indicate that you can't have a bowl of CBD gummy bears on your desk, right? Not cool. But it's happening. It's happening. I'm still shocked by it, but it's happening. So
We actually give our policy to all of our applicants at the time they take the job application. Is that?
yeah, I don't have a problem with anyone setting forth their expectations during if you handed your whole employee handbook to them and said, this is our culture, this is who we are, make sure we're a good fit for you before you accept an offer or you decide to continue with the process. I don't have any problem with that. Do you do drug testing? No. So making sure that everyone's on the same page before the relationship starts, I think is helpful.
Sort of a little bit off topic, but related. I had a call from an HR manager yesterday asking me about kombucha. It's not a drug, but it does contain alcohol. So
I would limit it to say that it just isn't something that it can appropriately be on the premise. Unless you allow alcohol generally. I know some employers have now opened up and are like, after 3:30, we have taps, you're welcome, everyone be responsible, do your thing. If you're gonna allow people to do that, you have to question, well, do you allow people to bring stuff in from off-site? Like, what's the alcohol content, what are our expectations? That kind of stuff. We've got taps. I start drinking at 3:30. Don't call me. No, I'm just kidding. I'm joking, guys. I don't. You can call me after 3:30.
She's the only one with a full
Don't make any comments about the next day.
and wines and beers
Funny bit.
in her office.
What happened this session? This is like academic Tawny gets so excited about this because on its face it's like, this is so boring, Tawny, just stop talking and move on, right? But the question was, do we include this new statutory update in the marijuana section of the presentation or in the unemployment section of the discussion? We decided that it was way sexier to do it in marijuana. So, what has happened is they've changed the definition in the unemployment statute for what for-cause termination includes, right? They've now updated it to include intoxication on duty or when reporting for work or unauthorized use of alcohol or marijuana while on duty, except for the use of marijuana permitted under Title 22, Chapter 558C. This is 22 MRSA 558.C. Now, all this does is, and this is a medicinal statute, so the medicinal statute only limits your ability to limit an individual from smoking marijuana on site if you also don't allow people to smoke tobacco on site, right? So you've got this language, may prohibit the smoking of marijuana for medical purposes on the premise. If the business or a landlord also prohibits all smoking on the premise, right? So from a medicinal standpoint, right, you can't say you can smoke cigarettes in this square foot or under this tarp or canopy, but you can't smoke marijuana there if they have a certificate, right? So that's what that says. And you also have to post notice to that effect, right? Now, you can have an individual who you refuse to hire or terminate if you're going to lose a federal contract or funding, right? But otherwise, there's no limitation. It does say that under the medicinal statute, it does not prohibit a restriction on the administration of marijuana on the premises when that would be inconsistent with the general use of the premise, right? What it comes down to is arguably on a break, someone who has a medicinal need for ingesting marijuana, if they have an edible, right? You can't limit the edible there. That's not going to be a for-cause termination, right? So, or unauthorized use of marijuana, so it's not permitted, right, while on duty, except for the use of marijuana permitted under Title 22, right, which would indicate that it is permissible, right? That you can't just say unauthorized use of marijuana while on duty, period. That's what I would have said. Like, if you're saying you can't use marijuana no matter who you are while on duty, that's sufficient to say it was a for-cause termination. But what they're saying is, you likely should not be terminating somebody if they're using marijuana on the premise if it's for medicinal purposes, which is a massive expansion from what we've been talking to clients about the fact that, yeah, you can't take action against them as a result of them having a certificate, but you could limit their ability to not ingest or to do. You don't do marijuana. Maybe you do. I guess I have to think about that. So I've never done marijuana. You can't limit their ability potentially to ingest marijuana based off of this language, I think, is indicating what the legislature meant by that language.
What about intoxication, even if you have a medical certificate? Presumably, you should not be intoxicated off duty, regardless of what you're.
The problem is you can't tell intoxication from marijuana. There's no way to tell someone's intoxicated. Richard?
Impaired.
Impaired is the same.
Impaired, you can do physical impairment. If They can't walk, they can't speak, they're slurred, they're stumbling. The same way you can do physical impairment on anything. You can't test for impairment with a test on marijuana because it doesn't tell you the current status of what their condition is. But you can still physically look and see. I mean, you don't have to have any employee who looks and acts unsafe in the workplace, doesn't matter what the cause is, you can react to that, you know? So you really are gonna have to, if somebody smells somebody, came back from their lunch break out in the parking lot and they're heavily smelling of marijuana, that's not gonna be enough. You're really gonna have to see something that you can have somebody testify to, that they physically saw the person having trouble, they were blurry-eyed, they were making funny speech stuff. We took them away from that and said, you know, we don't think you can deal with this, maybe you have to go home, maybe we have to let you go to a conference room and sit down. You know, you'll have to be careful about how you handle it. But clearly, if they are actually impaired and you can tell that physically and feel that you're safely confident about it, that's still gonna be okay as a reason for changing their current status.
Are there any positions that have a kind of a stricter requirement, for example, a medical doctor, nurse, someone who's actually administering meds or surgery or?
If you would lose federal contractor funding under the statute itself, our guidance, however, is if it's a safety sensitive position, that needs to come first and take the potential risk under the statute. Especially.
Tawny mentioned the Drug-Free Workplace Act because it changes.
Well, I mean, the Drug-Free Workplace Act means that you have to have a policy or practice in place. We can use it as a defense, but one of the problems with the Drug-Free Workplace Act is it only requires that once you receive notice of a conviction that you take action, right? So we can say that we believe in a Drug-Free Workplace Act, it's our policies and provisions to have a Drug-Free Workplace Act. That's gonna further support your position in taking the person out of work for a period of time, but you still have risk, which is one of the big problems with the Maine statutes.
Does the responsibility lie with the employee to notify the employer that they have a card, or are we allowed to ask?
No, I would wait for them to say it. I don't like to ask anyone if they're high. Just, yeah, and then, cause once you find out, I am a big believer that we don't ask anyone if they're high, we just either terminate or take adverse action against them as a result of what they did, not why they did it. So it's the what, not the why. And also if they just stink like a skunk, I usually send them home saying they're in violation of our attire and grooming policy. I don't need to tell them that I think it's marijuana or that I think that they're high. I just say you're in violation of the grooming policy and send them home for the rest of the day.
Again, another reminder just to check up on your job descriptions, make sure they're accurate in terms of what the essential functions are for the job. If it is a safety sensitive position, that's notated in there. When we talk about impairment, you know, it doesn't just go for marijuana in this day and age. There are a whole number of pharmaceuticals that you can get at CVS or Walgreens that are gonna cause impairment that create a potential safety concern for your workforce. So keep that in mind as well. And in terms of reasonable suspicion and things like that, we do have a checklist. You can see me afterwards if you'd like to get that sent over to you, but you wanna kinda have a basis for kind of what you're judging as impairment, if that is the case.
I just want to clarify, we had said before that you could say that people could not use medical marijuana that could be part of your policy. But then I think I heard you say that you can't exclude the use of medical marijuana if you allow people to smoke anything else on your property, is that correct?
Correct. We have 10 minutes left, and I want to be mindful of everyone's time. We are going to really go quickly through leaves of absences to get to talking about the new leave statute. And we're gonna really run through kind of the next stuff really quickly. We're not gonna take any questions, but see us afterwards if you have questions regarding any of it.
So the Maine Family and Medical Leave Act, or MFMLA, applies to private employers with 15 or more employees at one location. Eligible employees may take up to 10 weeks of unpaid leave within 2 years for the following reasons. birth of a child, adoption of a child 16 years of age or younger, serious illness of the employee or a covered family member, organ donation, or death or serious condition of a covered family member that occurs while he or she is on active military duty. Sick leave. There is no Maine law in effect right now requiring private employers to provide employees with sick leave, paid or unpaid. Employers may choose to grant a sick leave policy. Employers with 25 or more employees must allow an employee who receives paid leave, whether that's sick, vacation, or comp time, to use that time to care for an ill, immediate family member. That leads us to
What happened this session? So we had an act authorizing earned employee leave. It's LD 369 and it was signed on May 28th of 2019. This is the statute that everyone heard about and that got all the press coverage. Verrill Dana issued an alert 2 weeks ago, a week and a half ago. If you did not receive it, please see a member of the Verrill Dana team, give them your business card. We'll make sure that we get the alert out to you in case you can't read it on your printout. Specifically, we know very little about what this act says. Is it big? Is it life-changing? Maybe. It takes effect on January 1st of 2021. It applies to all employers that usually in the usual regular course of business have more than 10 employees, right? For more than 120 days per year. They begin accrual of leave at the time they start working. It must be paid at the base rate. They're entitled to some benefits, same benefits as the employer provides to employees who are out on other types of paid leave, and the employee must give reasonable notice. That's what we know. The things that we don't know are more important because right now there's very little action or activity that you can take moving forward, right? Things we don't know. Although the law provides that the employee's leave cannot cause undue hardship, as determined by the employer, we don't know how undue hardship is going to be determined. Is it going to be the same as under the ADA? What is an undue hardship? What amount of notice is reasonable? What constitutes an emergency or a sudden necessity, and who's going to decide that? How will individuals' current vacation or paid time off policies be affected by the new law? If you're already providing some type of paid leave, can you simply allow employers to use this type of leave concurrently with the leave that you're providing? Or are we in a situation which any employer who is already providing leave is going to have to provide additional leave under this statute? Can we establish a minimum increment on paid leave that the individual can use at each time? Is it use it or lose it? At the end of the year, can we get rid of it and start afresh, or will this just keep accruing and accruing? What kind of documentation can the employer seek? What happens if the accrued paid leave when the employee separates from employment? Are we going to have to pay that out? Can we have policies that limit the payment? Our contract employees who work whenever they want covered, this is that per diem question. If you have per diem staff, are they also earning it at the same rate? How does that work? Can an employer reduce other paid time off that it already has in effect in order to accommodate this new paid time off? What we don't know is much more significant than what we do know. We are truly just waiting for the Department of Labor to give us some more guidance. And if you're talking to people who say they know what this means, I would love to talk to them because I don't think we have answers to some of the biggest questions that are posed by this statute. What else happened this session? You're like, wait, Tawny, more in the leave section? An act to create veteran-friendly workplaces, LD 1654, it was signed on the 17th. Employers shall allow veterans to take time away from work to attend scheduled appointments at medical facilities that are operated by the VA. It's interesting because it doesn't apply to any veteran needs. It's only veteran needs that are applied to the VA. As long as the employee gives the employer notice, if no paid leave is available, they're permitted to take unpaid time. If paid leave is provided, they must be allowed to use that paid leave, or if they've already used all available paid leave, they must be permitted to take unpaid leave. It's not a huge statute. I mean, arguably, if you're seeing the VA, there might be some type of disability involved, so you likely had this obligation under the ADA, but just be aware of this obligation.
Do you require someone to take paid leave?
If they have paid leave available, yes, you must, good question. I'm not sure. I can get back to you because it says allow. So I'm not sure if your policies don't permit individuals to take unpaid leave, they must take all paid leave first
Yes.
before taking unpaid. I would say that your policy remains applicable. Workers' compensation. What happened this session? We're gonna do this really quick. Liz, in-house right now, for those of you who have not met Liz Johnson, she is a new associate in our practice. She works a lot with the workers' comp stuff. I'm gonna let her give a really quick update for everyone.
Sure, thanks Tawny. So there were some significant updates to workers' compensation this session. I'm sure many of you have seen it in the news that there were 24 bills proposed that really bring the system leaning toward an employee-friendly system and potentially produce some discord between sort of the employee side and the employer side in the system, like the pre-1992 systems, if anyone's familiar with that.
Can't hear you.
Oh,
Liz.
sorry. So basically what happened is they did reach a compromise on the provisions that did go through in this sort of omnibus bill that they're calling it. Some of the key provisions to be aware of is that there was an increase in the notice period from 30 days to 60 days for employees to report their injury. And there are also provisions that are increasing the benefits that employees get while being out on workers' compensation. So the weekly benefit has increased to 125% of the state average weekly wage from 100%. And there's also an increase in the amount of time that an employee can receive partial incapacity benefits, and that time period was increased by 2 years. So that notice period is one to definitely be aware of, that they do have longer to report an injury, and these provisions all take effect for injuries after January 1st, 2020. So,
Thank you, and also a large alert went out on this on Monday. If you're not on Verrill Dana's listserv, you didn't receive it, but we can get that to you again if you get someone your card. We are right at the end of our time, but a couple things that you'll notice in your slide. There was a change in the mini warrant statute, that's the mass layoff law. What happened was it was changed from 60-day notice of a mass layoff to a 90-day notice of the mass layoff. There was also a change in the provisions regarding the remedies. It wasn't a change statutorily in the content, just in the location of the statute. The next is what happened this session regarding unemployment. It removes the definition of remuneration received for the purpose of decreasing benefit eligibility, so that any money received for holiday pay, vacation pay exceeding 4 weeks of wages are excluded as definitions of remuneration in order for the employee to receive benefits. To the public employers in the audience, definitely see someone afterwards. I mean, the unionization statute that went into effect regarding the rights and the rights of employees in a public setting and the obligations in which employers must permit that activity to take place during work hours, at work locations, all of these things. It's really significant, and if you're in the public realm, you should definitely be speaking to your counsel and take a really good look at that bill. Thank you all for attending. Paul, no.
You're non-compete handout.
Yes, okay, sorry, good point. Great, good. Yes,
I feel like
this
you're
was
sitting
sitting on the governor's desk yesterday. It was we have knowledge that it was removed from the governor's desk yesterday. We do not know why it was removed from the governor's desk. We can tell you all the reasons why this is not a good statute and why we would remove it from the governor's desk, including limitations regarding restrictive employment agreements, the prohibition for certain non-compete agreements with certain workers who make under 300 times the federal poverty level. The federal poverty level right now is a little bit over 14,000. Requirements that employers must have when offering or providing non-compete agreements. The copy of the statute that was placed on the governor's desk is available in everyone's packet. Really, I woke up this morning and immediately looked. I can't find anything that discusses the status more so than we thought it was on the governor's desk, but we received word yesterday it was removed. We don't know what that means, so we will be providing updates through our alert system as to the status of this bill. So again, if you're not getting our alerts, please let us know so that we can get you on that list and you can get an alert on this. But our understanding is this bill has been taken off the governor's desk, and we're not exactly sure why, despite the fact that we all would have taken it off her desk if we could have. Thank you guys so much.
Likewise, if you guys would like to be on MassPay's list, we do a lot of webinars and seminars on HR, employment law topics, things like that. So if you're interested in getting on that communication